Some practice pointers. When you are filling this out or having remember, the owner must sign this. Okay, do not sign this yourself. If you're a contractor or a subcontractor, do not sign the notice of commencement, because now there's a sworn statement there that says that the owner is attesting to all the facts that are contained in this document. You don't want to be personally liable for that. Okay, but let's say you're assisting in the process, and you get down to number 9. Number 9 says expiration date of notice of commencement. The expiration date is 1 year from the date of recording unless a different date is specified. Make sure you specify a different date if you think the project is going to go longer than 1 year. Okay? If you think it's going to go 2 years, put that on there. If there's a delay, make sure that you deal with that issue. A lot of times what you can do is you can say the project completion date is 180 days as modified by the parties or subsequently amended by the parties. Something to give you a little bit of leeway so that if it goes beyond that time period, you've got a little bit of coverage. Why is the NOC important? Well, in addition to providing all the information that you need for your lien, your claim of lien, unless you are an architect, an engineer, professional services provider, will relate back to the date of your notice of commencement. Okay, that could be important because let's say you start work today and you lien the property 90 days from now. There could be judgments and other encumbrances that are in between the notice of commencement and your claim of lien. The statute provides that your claim of lien relates back to the date that the notice of commencement was recorded. So that's why the NOC is important, because it allows you to jump other judgments and encumbrances that happen on that property after the notice of commencement has actually been recorded. What happens if you don't have a notice of commencement? I get this question a lot. Well, you still have a lien, but your lien is good at the time that your claim of lien is actually recorded. It does not relate back to any point. Let's talk about actually serving and perfecting your claim of lien. Now, notices to owner. Most of you are familiar with the notice to owner process. When does it kick in? A notice to owner requirement kicks in if you are not in privity with the property owner. What does that mean? Well, the property owner is the person that actually owns the real property that you're improving. If you are not a contractor, a prime contractor, general contractor that is contracted directly with that entity, if you are a sub-sub, or a supplier to a general contractor, sub or sub-sub, then you will need to serve a notice to owner. Okay? Notice to owner. This is the form 713.06. Okay? It's got a warning up top. What you are doing is you are putting the owner on notice that you are out there, that you need to be paid, and if you're not paid, that you may lien the owner's property. So it's important for the owner to get this, but keep in mind, serve it on everybody upstream. Okay, it doesn't. If you are a subcontractor, it's worth an extra $5 to serve it on the sub, the prime, the owner, anybody that's listed on the notice of commencement, the lender, whoever's going to get you paid. I include anyone and everyone. Now, if somebody is listed on the NOC as being entitled to notice, you must serve them with this. Okay, so I serve it on everyone. Certified mail, return receipt requested. Okay, it's usually the cheapest and most effective way to get that accomplished. Practice pointer. Okay, the notice to owner must actually be received within 45 days. Okay, you can't drop it in the mail on the 45th day. That does not count. It has to actually be received. So make sure that you have it in the mail and have acknowledgement that it's been received in that 45-day time frame. One other thing to consider is that it specifically asks you here what type of work you're performing. The thing that you need to remember is try to be vague in general. Okay, if you're doing roofing improvements, put roofing improvements. But a possible problem could arise is, let's say you have both a GC license and an electrical contractor's license, and you send out a notice to owner that just reflects your electrical improvements. Then later during the course of construction, you're asked to actually use your GC license to do some structural improvements. Well, you should amend your notice to owner to reflect that as well, because it's possible that your lien could be limited to only the electrical improvements, and you don't want that to happen. The next thing I'd like to talk about is the actual claim of lien itself. And I showed you the form, but let's go over the time requirements. Yes, there's a question in the back.
Trent, tell me, what do you think about notice to owner services?
Okay, for those of you that couldn't hear that, the question is what do I think of notice to owner services? For those of you that don't know, notice to owner services will get your information and serve NTOs to whatever properties that you're actually performing work on. Notice to owner services can be good or bad, just like any other business, and as long as you're doing your due diligence, that's fine. I always, if you're in the process of using one of those, it doesn't hurt to do some double checking every once in a while, especially on bigger projects, just to make sure that everything is done correctly. But generally speaking, they're fine. They're a good way to do it. Just make sure that you're with somebody that's reputable that you can trust.